Hello everyone, welcome back to our channel US Immigration. We hope you're doing great. In this video we will talk about the green card through INA 245 I-adjustment. INA 245 I provides a special pathway for certain individuals who entered the US without proper documentation or overstayed their visas to adjust their status and obtain a green card. This video allows eligible applicants to remain in the US while applying, making it a crucial option for those who might otherwise face barriers to permanent residency. If you are interested in this, so to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So without any further delay, let's jump into the video. Section 245I of the Immigration and Nationality Act, as amended by the Legal Immigration Family Equity Act and Life Act Amendments of 2000 Pub. L 106 to 553 N-554, enables certain individuals who are present in the United States who would not normally qualify to apply for adjustment of status in the United States to obtain lawful permanent residence get a green card regardless of the manner they entered the United States, working in the United States without authorization, or failing to continuously maintain lawful status since entry. To qualify for this provision, you must be the beneficiary of a Labor Certification Application Form ETA 750 or Immigrant Visa Petition Forms I-130, Petition for Alien Relative, or I-140, Immigrant Petition for Alien Worker filed on or before April 30, 2001. You must complete Supplement A to Form I-485, Application to Register Permanent Residence or Adjust Status, to apply under Section 245I provisions and submit it with your Form I-485. In most cases, you must also pay an additional $1,000 fee. Eligibility criteria. You may be eligible to receive a green card through Section 245I if you are the beneficiary of a qualified immigrant petition form I-130 or I-140 or application for labor certification form ETA 750 filed on or before April 30, 2001, were physically present in the United States on December 21, 2000, if you are the principal beneficiary and the petition was filed between January 15, 1998 and April 30, 2001, are currently the beneficiary of a qualifying immigrant petition, either the original form I-130 or I-140 through which you are grandfathered, or through a subsequently filed immigrant petition or an application for labor certification. Properly file Form I-485, application to register permanent residence or adjust status, and Form I-485 Supplement A. Pay the $1,000 fee unless exempt. Are physically present in the United States at the time you file Form I-485 and Supplement A, have a visa immediately available to you, are admissible to the United States or eligible for a waiver of inadmissibility or other form of relief, and warrant the favorable exercise of discretion. This means the positive factors in your case outweigh the negative factors. Depending on the circumstances, a spouse or child of a grandfathered individual may also be a grandfathered or may be eligible to adjust status as a dependent under Section 245I of the INA. Qualifying petition or labor certification. Labor certifications or visa petitions filed to preserve an individual's adjustment eligibility under Section 245I must be both properly filed, signed, and submitted with the correct fees, and approvable meritorious based on the facts and non-frivolous when filed. To meet this test at a minimum, the filing must be timely filed by April 30, 2001 and meet all applicable substantive requirements approvable when filed. Deficiencies such as lack of fee or original signature disqualify the submissions. If the petition or labor certification is withdrawn, denied or revoked. If you withdraw the petition, or if USCIS or the former Immigration or Naturalization Service denied or revoked your petition after approval, you may still be grandfathered depending on whether the visa petition or labor certification was approvable when filed. To remain eligible, the changed circumstances must relate to factors beyond your control, rather than the merits of the petition at the time of filing. If the petitioner dies or the employer otherwise is unable to maintain the petition. As long as the petition or labor certification application was approvable when filed, you should remain grandfathered. If the petitioner dies, family member who filed the petition divorces you, employer who filed the labor certification or subsequent Form I-140 goes out of business, petitioner or the employer chooses to withdraw the petition or labor certification, petitioner or employer is otherwise not able to maintain the petition or labor certification application process. To obtain a green card, you must file Form I-485, application to register permanent residence or adjust status. You must also file Supplement A to Form I-485 with fees at the same time unless you meet an exception. For more information on exceptions, please see the instructions for Supplement A to Form I-485. Supporting evidence for Form I-485. You should submit all of the following evidence with your Form I-485. 2 passport-style photos. A copy of your government-issued identity document with photograph. A copy of your birth certificate. A copy of your passport page with a non-immigrant visa if applicable. A copy of your passport page with admission entry or parole stamp if applicable. Form I-94, Arrival Departure Record if applicable. Form I-693, Report of Medical Examination and Vaccination Record. Form I-864, Affidavit of Support, if applicable. Form I-944, Declaration of Self-Sufficiency, if applicable. Either the concurrently filed immigrant petition or Form I-797, Notice of Action for the pending or approved immigrant petition that you are using as your basis of adjustment if you are not adjusting based on the grandfathered immigrant petition. The correct Form I-485 filing fee, and a copy of the immigrant petition or labor certification or Form I-797, Notice of Action, that you are using as the basis for 245I grandfathering, proof of your physical presence in the United States on DC. 21, 2000, if applicable, and $1,000 fee, if applicable. Employment and travel authorization. Generally, when you have a pending Form I-485, you may apply for employment authorization by filing Form I-765, Application for Employment Authorization. You may also apply for an advance parole document by filing Form I-131, Application for Travel Document. An advance parole document authorizes you to appear at a port of entry to seek parole into the United States after temporary travel abroad. If you need to leave the United States temporarily while your Form I-485 is pending, please see the instructions for Application for Travel Document webpage for more information. Generally, if you have a pending Form I-485 and you leave the United States without an advance parole document, we will consider you to have abandoned your application. Adjustment of status under Section 245I of the INA and Life Act provisions. Many people mistakenly believe that Section 245I of the INA constitutes amnesty, that is, forgiveness of unlawful presence or other breaches of status. On the contrary, unlawful presence continues to accrue until you file an application for adjustment of status. Section 245I does not protect you from deportation, nor does having a grandfathered petition or application for labor certification place you in a period of stay authorized by the Secretary of Homeland Security. For example, if you are illegally in the United States, you accrue unlawful presence until you properly file an application for adjustment of status. If you accrue 180 days or more of unlawful presence in the United States and then depart the United States, even if you previously obtained advance parole, you will trigger a bar to adjustment of status or immigrating on an immigrant visa, a 3-year or 10-year bar under Section 212 and 9B of the INA. In most instances, Section 245I does not forgive this bar. Other grounds of inadmissibility may apply even though you may have an application for adjustment of status under Section 245I. Unless you obtain a waiver or some other form of relief for any ground of inadmissibility, you may not qualify for adjustment of status under Section 245I. Furthermore, a United States employer who files a labor certification or Form I-140 with an unauthorized individual as beneficiary will be subject to sanctions if they are discovered to be knowingly employing that individual before adjustment of status or USCIS granting work authorization. Filing Form I-485 under Section 245I does not protect an individual against removal based on an applicable ground of inadmissibility by Immigration and Customs Enforcement. Once the individual files Form I-485, they become eligible for work authorization and may work if they apply for and obtain an employment authorization document. Background of Section 245I of the INA. In 1994, Congress enacted Section 245I of the INA, permitting certain individuals who were otherwise ineligible for adjustment of status in the United States to pay a penalty fee for the convenience of adjusting status without leaving the United States. Before enacting the Life Act amendments, the window for preserving adjustment eligibility under Section 245I ended on January 14, 1998. After that, only grandfathered individuals beneficiaries of labor certifications or immigrant visa petitions filed on or before that date were eligible to adjust status under Section 245I. The cutoff date of Section 245I changed several times, however. Then President Clinton signed into law a provision that changed the nature of Section 245I to grandfather those individuals in the United States for whom an immigrant visa or application for labor certification was filed on or before January 14, 1998. On December 21, 2000, the Life Act amendments temporarily restored eligibility under Section 245I by replacing the previous cutoff date of January 14, 1998 with a new date, April 30, 2001. Accordingly, a beneficiary of a labor certification application or immigrant visa petition filed on or before April 30, 2001 preserves an individual's eligibility to adjust status under Section 245I if they meet certain conditions. The Life Act added a significant requirement to Section 245I. If the qualifying petition or labor certification was filed after the previous cutoff date of January 14, 1998, the individual must have been physically present in the United States on the date of enactment December 21, 2000 to qualify for Section 245I benefits under Life. Section 245I grandfathers individuals as well as the applications or petitions filed for them. The basis of a grandfathered individual's eventual adjustment, however, is not restricted to the application or petition filed to preserve adjustment eligibility. The grandfathered individual's application for adjustment of status may be based on any adjustment provision available to the individual at the time of adjustment. For example, a qualifying Form ETA 750 filed on or before January 14, 1998, preserves the individual's eligibility to adjust status after that date. However, the filed ETA 750 does not commit that individual to adjustment on the basis of an employment-based petition. If, after January 14, 1998, the individual was named as beneficiary in a family-based petition or won an immigrant visa in the diversity lottery, they may adjust status on the new basis. The immigrant visa won in the diversity lottery will not grandfather an individual but may be used as a basis of adjustment by an individual who is already grandfathered under Section 245I. INA 245I serves as an important option for individuals seeking a green card despite immigration challenges. By meeting the eligibility requirements, applicants can pursue lawful permanent residency without leaving the U.S., making it a critical tool for keeping families together and building a future. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video. Till then, take care.
Hello everyone, welcome back to channel US Immigration. We hope you're doing great. In this video, we will talk about the green card through INA 245I adjustment. Section 245I of the Immigration and Nationality Act (INA), as amended by Legal Immigration Family Equity Act, Life Act of 2000, allows certain individuals who are otherwise ineligible for adjustment of status to apply for a green card while remaining in the US. This provision is available regardless of how they entered the country, unauthorized employment, or failure to maintain lawful status. To qualify, the applicants must be the beneficiary of a labor certification or immigrant visa petition filed on or before April 30, 2001, and in certain cases must have physically present in the US on December 21, 2000. Eligible individuals must file Form I-485 application to register permanent residence along with Supplement A and pay a 1,000 penalty fee. This process allows applicants to adjust their status without leaving the country, provided they meet other requirements such as having a visa available and being admissible or qualifying for a waiver. The applicant's labor certification or visa petition must have been properly filed and approvable when filed. If the petition is later withdrawn or denied, the individual may still be eligible provided the initial filing met all substantive requirements. The Section 245I also applies if the petitioner dies, the employer goes out of business, or the petition is otherwise withdrawn, as long as the petition was valid when filed. Applicants can also apply for employment and travel authorization while their Form I-485 is pending. However, they must obtain advance parole before leaving the US to avoid abandoning the application. It is important to note that Section 245I does not grant amnesty or forgiveness for unlawful presence, and certain bars to re-entry may still apply. Additionally, employers who file petition for unauthorized individuals may face penalties if discovered employing them before the adjustment is approved. The INA 245I provision was introduced in 1994 and later amended by the Life Act, which extended the eligibility cutoff date to April 30, 2001. This provision grandfathers eligible individuals, allowing them to adjust their status based on the other petitions or visa applications if they meet the requirements. Despite challenges, the Section 245I offers a crucial pathway to lawful permanent residency, enabling families to remain united while navigating the complexities of US immigration laws.